Buenos días a todos y todas. Queríamos compartir con ustedes el orgullo de la propuesta Argentina Deliveries.
We wanted to share with you, we are very proud of Argentina Delivers proposal.
Para resolver nuestros obstáculos al desarrollo, debemos construir una mejor oferta de bienes y servicios más diversa y más basada en el conocimiento.
To solve the obstacles to development, we must build a better supply of goods and services.
Y hoy los servicios ligados a la tecnología son una excelente muestra del valor agregado argentino, ayudando a empresas y personas con sus proyectos en Estados Unidos y en el mundo.
Today, the services linked to technology are an excellent examples of Argentina added value and helping companies and people with their export projects in the US and around the world.
Para seguir creciendo, necesitamos continuar fortaleciendo nuestro sistema de ciencia y tecnología. Y este es un buen momento en las políticas de ciencia y tecnología en Argentina. El gobierno apoya con fondos y el Congreso con leyes.
To continue growing, we need to continue strengthening our science and technology system. It is a good moment in science and technology policies. The government supports with funds and laws.
Queremos más profesionales, más startups, más innovación y más tecnología argentina que transforme la salud, los alimentos, que cuide el medio ambiente, que impulse la transición energética y que amplíe oportunidades laborales en tiempos de profundización del paradigma digital.
We want more professionals, more startups, more innovation, and more Argentine technology to transform health, food, caring for the environment, promoting the energy transition, expanding job opportunities while deepening the digital transformation.
Más universidades, más ciencia y tecnología tienen que ser nuestras llaves para abrir el camino hacia un desarrollo con inclusión y sostenible.
More universities, more science and technology. These are our keys to open the way towards an inclusive and sustainable development and growth.
Y para lograr una buena combinación entre inversiones e innovación, también necesitamos atender las regulaciones. Por eso hoy vamos a compartir un diálogo abierto y bien informado sobre protección de datos personales.
And for a combination of growth and investments, and regulations are utterly important. This is why today we are going to share an open and well-informed dialogue on protection of data, personal data.
Agradecemos a Mariano Perosotti por su trabajo, a Mariano Zuckerfeld por su colaboración y a Beatriz Anchorena por su importante tarea para lograr este diálogo.
We wanted to thank Mariano Perusotti for his work, Mariano Zuckerfeld for his collaboration, and Beatriz de Anchorena for her support to make this dialogue possible.
Para finalizar, felicito al embajador Jorge Argüello y al equipo de la Embajada Argentina y a todas las agencias que contribuyeron para esta iniciativa de Argentina Delivers.
I wanted to congratulate the Ambassador Jorge Argüello and his team for making this initiative possible and this session here today.
Thank you.
Thank you very much. And now, since Raquel Silva, the DOC desk manager, is not available, we will give the floor to Sam Sosu from the DOC to present his presentation on the legislative framework in the US.
Yeah. So good morning, everybody. My name is Sam Schofield. I'm a policy advisor at the U.S. Department of Commerce in the Office of Digital Services Industries. I'm joined here by my colleague, Chris Detrolio, who is our Argentina and Brazil desk officer at the Department of Commerce. It's a pleasure to be here today, and thank you for inviting me. So just quickly, in my role as policy advisor, my portfolio primarily covers data policy issues and also artificial intelligence policy with our trading partners in Latin America, to include Argentina. So I'm going to talk today about US policy views and overall framework for data protection and privacy, including in Latin America. So slide. Okay, next slide, please. Okay, so just at a very high level, the United States has fairly consistent positions on privacy and data protection. But in the Biden administration, there are three main priorities with respect to data privacy and regulation of cross-border data flows. First, it is our position that we want to, in any bilateral or multilateral relationship, put forward frameworks and policies that enable the cross-border flow of data with adequate, sufficient protections on that data as it travels across jurisdictions. And we also look to combat data localization requirements in any form. Obviously, there are exceptions to data localization when it comes to national security or defense data. But from the commercial perspective, the general position is that commercial data should be able to flow just with enforceable protections on that data. Second, we prioritize direct bilateral negotiations with jurisdictions around the world, including currently with many of our trading partners in Latin America. And lastly, and this is a very important initiative for the United States and also the Department of Commerce, which is supporting the globalization and expansion of the APEC cross-border privacy rules system in order to enable broader participation in that privacy certification system by countries outside of the APEC bloc. And I'm going to talk primarily about that initiative today. So just briefly as an overview and an introduction to the CBPR system. The APEC cross-border privacy rules system was established in 2011 within the Asia-Pacific Economic Cooperation Group. And it was initially endorsed by all 21 members of APEC. So the APEC CBPR system is a multilateral, voluntary, and government-backed privacy certification for companies to be able to demonstrate to multiple jurisdictions simultaneously that they can comply with internationally recognized data privacy protections. And those take the form of 50 different CBPR program requirements. And those requirements indicate that those rules on data protection and privacy are enforceable in all of the 9 jurisdictions that recognize the certification. The benefit of the CBPR system from our perspective is that it bridges gaps between differing national data privacy laws and it allows for countries to not have to change their domestic laws and regulations, while also giving companies a common certification mechanism to be able to reach baseline compliance with different laws simultaneously to allow important commercial data to flow between subsidiaries and vendors and their network, their ecosystem of business across jurisdictions. And also the structure of the CBPR system enables enforcement cooperation between participating economies' data protection authorities. So the first step in any economy joining and any country joining the CBPR system is that they have to designate a data protection regulatory enforcement body to participate in a cooperative network to be able to share information related to investigations and ensure compliance and enforcement of the CBPR program requirements for companies. And lastly, I would just mention that the CBPR certification is recognized in the US-Mexico-Canada agreement as a valid data transfer mechanism. It's recognized under the Chapter 19 on electronic commerce. Next slide, please. So just very briefly, currently there are 9 countries and economies that participate in the CBPR system. They are there on the left of the screen. In total, we have 1,800 total certified entities that have the CBPR certification across 50 different companies. There are also 40 PRP certified companies. What that is it's a similar certification, but specifically aimed at processors that work with, for example, large tech firms to do data processing or analysis on their behalf. When I talk about the global CBPR forum briefly, I'll explain that we're looking to consolidate those 2 certifications since they're very, very similar. But that's the current breakdown of the certified companies. And lastly, there are 9 accountability agents, and what those are independent certification bodies that each country designates to be the independent third-party organization that certifies companies to participate in the CBPR system. And those can take the form of private entities. In the United States, we have 5 accountability agents. They're all private sector or nonprofit firms, but they can be government agencies. In the case of Japan and Korea, they use public agencies as their accountability agents. The only requirement is that if a public agency, the accountability agent has to be distinct from the enforcement body. And we currently have 5 of those, and there are 4 others with 2 in the process of certification. Next slide, please. So just quickly, there are 3 primary stakeholders in the CBPR system. There are the countries and jurisdictions. Like I mentioned earlier, first step is the country has to designate an enforcement body that can participate in the cooperative network. They have to submit an application to a rotating joint operating panel of 3 countries to review their initial application. And then they also have to, once in the CBPR system, nominate a domestic accountability agent. Like I said, the accountability agents are independent certification bodies, but also importantly, they are responsible for monitoring companies' compliance with the CBPR program requirements, receiving complaints from consumers, conducting dispute resolution. However, I just want to emphasize, because this is important in our conversations with many other countries about joining this system, the accountability agents do not supplant the authority of an enforcement body, of a domestic enforcement body. A domestic data protection authority can take action against a company at any time. The accountability agents are intended to provide an additional layer of accountability and oversight, independent from the government, that enables 2 different entities to be kind of continuously monitoring how companies are complying with these requirements and their obligations to consumers about how they handle their data. And lastly, certified companies submit their applications to an accountability agent in their country. They have to work with the accountability agent to modify any privacy policies within their corporate structure to align with CBPR program requirements. And like I said, they're subject to continuous monitoring. And for both accountability agents and certified companies, they have to get recertified again after their first year and then every 2 years. Next slide. Benefits of the CBPR certification, they're up here on the screen, but generally for companies, this can often help smaller companies that are just starting to expand to global markets develop an international privacy program or system for their company by going through the CBPR certification process. It also demonstrates accountability and trust to consumers because they have to be able to have an independent body review their privacy practices. A consumer can contact the accountability agent anytime to raise concerns about how they're treating their personal data. So there's a lot of transparency with the certification, but it also streamlines business operations across Asia Pacific markets and North America. And the reason that we are globalizing this certification is we want to be able to expand those benefits to companies and consumers by allowing the certification to be recognized and utilized in different markets outside of APEC. For consumers, like I said, it signals accountability and transparency. It provides them with a more readily accessible dispute resolution mechanism if they don't want to go directly to the enforcement body in the country for a minor dispute. But then if a dispute cannot be resolved by the accountability agent, then it can go to the enforcement body in the different governments for investigation and potential sanction. And lastly, it obligates companies to comply with both domestic privacy law and CBPR program requirements, even as that data crosses borders. I just want to emphasize, sorry, just one thing. Sorry, just one thing. Oh, okay, sure thing. Sure. Just want to emphasize that although there are common CBPR program requirements that each country agrees to, companies are still obligated to comply with domestic law in each of the countries. So if there is a unique requirement in one country, say that they have to report a data breach within 3 days, that is not in the CBPR program requirements, but if that is in Japanese law, they have to comply with that. Purpose of the CBPR program requirements is that by 9-10 different countries recognizing them, it allows companies to achieve baseline compliance with multiple countries simultaneously. so that they know in general on a day-to-day basis, they are complying with the law. And then maybe there is an extra 20% of unique requirements in each country that they have to also comply with, but it streamlines their compliance ability. Slide, please. So on April 21st of this year, the United States and 6 other members of the CBPR system announced the establishment of the Global CBPR Forum, which will be a similar privacy certification system based on the APEC CBPR program requirements, but administered independently and separately from APEC. Subsequently, Australia and Mexico have notified the other 7 countries that they intend to join the declaration, and we're hoping to formally launch the Global CBPR Forum with an independent secretariat and administration system by early 2023. So up on the screen, you can see just there was a statement from our Secretary of Commerce announcing the establishment of the Global CBPR Forum. On the top right of the screen is a photo from the first Global CBPR workshop that we held in Hawaii in late April with 15 other jurisdictions, meaning all of the current APEC CBPR members, as well as several countries not currently in the system, including the United Kingdom, also Colombia, Brazil, Peru, and Chile. So we had good attendance with that, and we are having a second global workshop in Korea next month. Next slide, please. So just a summary of the purpose and objectives of the Global CBPR Forum. Again, we expect it to be fully operationalized by early next year to immediately allow for countries outside of APEC to apply for membership if they so choose. On that note, we are in discussions with at least a half dozen countries outside of APEC about joining the Global CBPR Forum, including 3 to 4 countries in Latin America, including Brazil, Colombia, Chile, and Peru. So as far as the objectives, we are looking to increase regulatory interoperability in data protection laws across multiple regions. So not just limiting that interoperability that we have achieved within the APEC region, but also expanding that to include other countries in the Middle East, in South Asia, and in Latin America, to broaden the ability of companies to have common mechanisms to transfer data safely across jurisdictions, as opposed to siloed unique compliance requirements in each jurisdiction. We also expect the Global CBPR Forum to strengthen economic and commercial relations, especially in regulations, especially in the digital economy, which is of increasing importance to modern trade. And we also just want to be able to create an internationally enforceable certification to facilitate cross-border data flows. I want to put an emphasis again on the enforceability of this certification. It does not allow companies to be absolved from their obligations if they transfer data, say, from Japan or Korea to the United States. And that is the importance of that cooperative network that we have. Next steps. So like I said, we're about to establish the forum in early 2023, but to do that, we're finalizing new charters for the joint operating panel for the cross-border privacy enforcement arrangement, the cooperative network. We're also working on establishing an independent physical secretariat for the CBPR forum and advisory councils, things like that. And we're also reviewing current program requirements to identify if any modifications need to be made in order to accommodate new countries that we are engaging about future membership. And we're developing criteria for how we will approve applications from new countries and jurisdictions to become members. It's been some time since we've changed the membership requirements for this system. So we need to make sure that we have common criteria to be able to collectively evaluate new membership applications, since at least currently everything in the CBPR system is done by consensus, not majority. And lastly, we're engaging with countries within and outside of APEC about the benefits of the CBPR and future membership. Next slide. So I just wanted to briefly run down, what is the relevance of this certification to Argentina, since we are at the Embassy of Argentina today. So very generally, it's relevant to the trade and economic relationship between Argentina and the United States. I understand that we do technically have somewhat different approaches to data protection and privacy regulation, but I would note that there are 20 US CBPR certified companies that already have operations in Argentina, and several of them, if you look on the CBPR website, where it lists out the scope of corporate entities that are subject to that certification. Several do list their Argentinian subsidiaries as required to comply with those requirements. And also, I just would note briefly that there have been some initial discussions between our Department of Commerce and counterparts in Argentina about a formal digital dialogue that would likely include discussion of data and privacy policy. The CBPR certification also can strengthen market access for Argentinian companies in North American and Asia Pacific markets by giving a common certification that can be applicable to multiple markets simultaneously. So just as an example, if there are, pymes, if there are, small or medium-sized businesses that are looking to work with larger technology companies that are CBPR certified, this is the type of certification that might expedite their access to working with those types of companies across countries in North America and the Asia Pacific. And it also just increases transparency into companies' privacy practices for consumers that are customers to CBPR certified companies. Every piece of information about the company and their privacy policies and how they were certified is available online. And they always have access to accountability agents for dispute resolution. And lastly, just specific to Argentina's data protection regulatory framework, I would note that your existing law 25.326, as well as proposed modifications to that law, do have provisions that allow your data protection authority to either develop or recognize international certifications. It does not mean that international certifications are currently recognized, but there is that provision in Argentinian law. So I believe that at least allows for starting a dialogue on this topic. So one more slide I have here. So I know I was asked before coming here to briefly talk about the new EU-US data privacy framework. I would note up front that I did not work on this directly. We have a separate team in my office that deals with all negotiations and relationships with the European Union. However, as many laws in Latin America and other regions are increasingly modeled off of the European Union's general data protection regulation, we certainly are familiar with the EU regulatory model and take it into account in everything we do. So just briefly, the EU-US data privacy framework is a culmination of more than 2 years, actually, of important work and negotiations between the United States and the European Commission to be able to establish a successor mechanism for data flows between the European Union and the US. After the original program, the Privacy Shield, was struck down by the European Court of Justice in July 2020. So we're very happy that we've been able to bring this to conclusion and are now operationalizing this new framework. It was announced, so sorry, just quickly, on July 16th in 2020, that was when the Schrems 2 litigation resulted in the Privacy Shield program being struck down by the European Court of Justice. Then this March of 2022, the US and the European Commission reached a deal in principle to address that decision and provide a replacement system mechanism. And then on October 7th, President Joe Biden signed the executive order on enhancing safeguards for the United States signals intelligence activities, which will be the basis for this new agreement. It requires the US to put in place a new executive order establishing more redress mechanisms for European consumers to inquire as to how their data may have been accessed or used by the US intelligence community. And on the bottom of the screen are some key facts just about the organizations that were involved in this project. The US Department of Commerce played a big role. And then we hope that this mechanism will now provide US companies with more certainty and a clear mechanism to be able to make voluntary, legally binding commitments to comply with data privacy requirements in the European Union when transferring personal data associated with commerce between the United States and the European Union. And like I said, it includes strengthened safeguards for US signals intelligence. So yeah, I'm happy to talk more about that if asked, but that's the presentation for now. Thanks.
All right, thank you so much, Sam. Like certainly how CVPR can fit into Argentina framework is very interesting for us. And certainly the information regarding the latest negotiation with the EU is also very interesting for us. New principles, new set of standards. Our companies are very interesting too. Now we'll give the floor to Mariano Perusotti, who will give the framework in Argentina. And then we will open the floor for Q&A. We have a lot of experts online from the side of Argentina also as well, so probably they will have a lot of questions. So now, Mariano, the floor is yours.
Thank you very much, Luz. Thank you for having me here. It's a huge privilege to be here in this event, an extraordinary event, and share the panel with outstanding professionals. My name is Mariano Perusotti. I am currently partner at OHAM BF. It's a law firm in Buenos Aires. We advise companies on personal data protection and technology. I am currently also the co-chair of the International Association of Privacy Professionals chapter in Buenos Aires. During my presentation, during my presentation, I will address the following topics. First, I will provide a legal description, a general overview of the Argentine legal framework. Then we will discuss the new data protection draft bill that was prepared by the Argentine Data Protection Authority. And finally, some remarks on the cross-border data transfer issue. The Argentine legal system is quite complex. We have several provisions in the Argentine Constitution recognizing in the Argentine Constitution and the human rights treaties, recognizing the privacy rights, as well as the habeas data remedy, which is an court action incorporated in the Argentine Constitution in year 1994. In year 2000, Argentine Congress passed the Argentine Data Protection Law that was further regulated by the decree number 15508 of 2001, which created the Argentine Data Protection Authority. The DPA has the task of enacting regulations complementing the Argentine Data Protection Law. And the Argentine Data Protection Law was the first comprehensive personal data protection law in the region. It was quite developed by that time, I mean by the 2000. It was strongly influenced by the European Directive on Personal Data Protection and the Spain's data protection law that was called LORTAD of year 1992. The PDPL provides a very, very broad definition on the term personal data, including not only the information covering not only the information of individuals, but also of legal entity, which is kind of strange because generally regulations around the world only protect the information, the personal information of individuals. Argentina obtained in year 2003 the EU adequacy decision in order to freely transfer the information from European citizens to Argentina without any restraint or condition. In the last year, Argentina joined Convention 108 of the Council of Europe and signed also Convention 108 Plus. The ratification of this last convention is still pending in Congress. When we advise companies doing business in Argentina, we generally speak about the obligations they have to follow or they have to comply. These are the main issues that a company doing business in Argentina should consider. First, they must treat or process the information according to the PDPL principles, as for instance, the data quality principle, the purpose limitation principle, the proportionality principle, the data retention principle, the lawful principle. They are very similar to other regulations that are inspired on the GDPR or the former EU Directive on Personal Data Protection. The Argentine regulation currently only recognizes the consent as legal basis for the collection of personal data. Unlike the GDPR and the Brazilian LGPD and other very recent regulations around the world, we do not recognize the legitimate interest as a legal basis for the collection of personal data. When collecting personal data, a data controller must inform about the data processing activity to the data subject. This is, the transparency obligation, which is quite similar to the Article 13 and 14 of the GDPR. But it is the list of information that has to be included or has to be informed to the data subject is not as extensive as in the case of the GDPR. Moreover, if a company, if an organization is considering transferring personal information to another data controller or a data processor, certain conditions shall be met. For instance, in the case of transferring information to a data processor in the context or in the frame of a service agreement, then a data processing agreement must be executed. And this data processing agreement must include specific clauses. Moreover, a data controller or data processor must implement adequate technical and organizational security measures and also execute NDAs or confidentiality agreement to all the people that are involved in the data processing activities. There is a specific obligation in the Argentine data protection law that is very, very common or very well known, that is the registration of database, which involves the obligation to report the data processing activities to the data protection authority. Finally, when a data controller receives a request of a data subject, it must be responded in a specific time frame. As to this last point, we can define the data or list the data subject right as the following. First, the data subject has the right to access to the information. It also has the right to update, correct, and request the removal of the personal data stored in the relevant database, as well as request the confidential treatment of the personal data. In the case of marketing activities, a data subject may request the opt-out or may exercise the opt-out right. And also, in general cases, the consent provided can be withdrawn. In the case of infringing a provision of the personal data protection law, the Argentine Data Protection Authority may impose several sanctions, including fines. As you may see, the fines are not very high. The reason of this is because the fines are included in Argentine data protection law, which was enacted, as I mentioned, in year 2000. So it's kind of outdated. Also, that the subject have several remedies in case of violation of their rights. During the last years, many initiatives have been introduced in Congress to amend the data protection law. As I mentioned before, our law is quite old, is outdated, and must be in a kind of way refreshed or created a new standard on personal data protection. In that sense, recently, the Argentine Data Protection Authority initiated a reform process with the aim of amending or creating a new system that could be in a kind of way similar to other regulations around the world, for instance, the GDPR. In September this year, the DPA released the the first draft bill, and opened a public consultation process. Many organizations, public sector, private sector, as well as civil society have introduced or had the opportunity to present, submit different opinions on this draft bill. This period, this open public consultation process concluded last October 11th. Now the DPA is considering all the commentaries submitted in the context of this public consultation process, and it is expected that then the executive branch will introduce a bill in Congress following this draft bill, of course, and this bill is also expected, according to the official agenda schedule, to be discussed in Congress during this year or the next one. To briefly explain about this new draft bill, we shall start saying that this text is following the provisions of the GDPR. So we will find a specific provision on an extraterritorial scope, which is quite similar to Article 3 of the GDPR. Also, this draft bill extends the legal basis for the data processing activity. Now, the legitimate interest, according to this draft bill, is recognized as a new legal basis. We will not rely, if this draft bill is approved finally by the Congress, we will not only rely on consent as the reasons to validate any data treatment procedure. Moreover, the data protection bill includes a specific obligation for companies to appoint a mandatory data protection officer in specific cases. In the case of a foreign company doing business in Argentina and addressing Argentine data subjects in the context of offering products and services, and representative will have to be appointed. This is quite similar to Article 27 of the GDPR. Moreover, in certain occasions, a data protection impact assessment will have to be conducted, and if a company or any organization suffer a data breach, there will be a report obligation within 48 hours of knowing about this incident. The catalog of rights granted to data subject is extended. For instance, data portability is recognized according to the draft bill, and also it should be noted that the amount of fines were increased. As I mentioned before, different stakeholders, the organization, chambers of commerce, and civil society have introduced, presented, or submitted different commentaries to the draft bills. The main concerns are on the following issues. For instance, on definitions, many papers explain that more clarity is needed about certain defined terms. As to the legal representative, it was requested to remove the joint and several liability, as well as in the case of data breach notification. There is a specific request to extend the term to notify the authority. Also, as to data subject rights, the term granted in the explained or stated in the draft bill to answer a request was of 10 days. So many requested the term to be extended in a certain way. Also, there are many concerns about the amount of fines and the obligations of data processors. Finally, I will take the last minutes to discuss something that was also mentioned by Sam before. He explained it very well on these challenges on international data transfer. As you may know, up to now, the US has not enacted a federal comprehensive personal protection law. This is a different approach to the European Union, who has enacted the GDPR. Before the GDPR, we had the European Directive on personal data protection, and both had this kind of horizontal approach, not sectorial, unlike the United States regulations. So the GDPR, as well as the former European Directive on personal data protection, both include strong restrictions on the cross-border data transfer, and that was the reason why the EU Court of Justice invalidated first the safe harbor in the year 2015 in the case Schrems 1, and then the privacy shield in the year 2020, and this led to the discussions and the starting negotiations between the EU and the US toward a new data protection framework. This, as Sam mentioned before, this agreement was reached recently and includes commercial data protection principles to which companies may self-certify. This is a kind of, could be a privacy shield 2.0, an executive order, and DOJ regulations. As Sam commented, the White House published recently an executive order that addressed those concerns raised in the context of the Schrems 2 decision, meaning limiting the US surveillance activities, particularly signal intelligence, and also grant redress rights to the European or to non-American citizens. This agreement is binding or will be binding upon European, Europe, and US, and in principle has no effects to other jurisdictions, which is quite important because, as I mentioned before, Argentina, currently regulations in Argentina has similar restrictions on the cross-border transfer to non-adequate jurisdiction. In that sense, Article 12 of the Argentine Personal Data Protection Law prohibits the cross-border transfer to non-adequate jurisdiction. And the current wide list of adequate jurisdiction does not include the United States. So any organization trying to transfer information from Argentina to the US must necessarily rely on any of the following three options. First, to obtain the consent of each data subject, which in some cases is almost impossible. The second one will be to execute an international data transfer agreement. And the third one will be to rely on binding corporate rules or self-regulation regimes. As I mentioned, although this transatlantic data protection framework will apply only to Europe and US, the executive order as drafted as it is may be used as the basis or as a platform to further negotiations between the US and Argentina to kind of create another venue to transfer information to the US, which will be of much help for organizations in Argentina or foreign entities in US doing business in Argentina that need to be access to information based or obtained in Argentina. To conclude my presentation, as I mentioned before, the PDPL was one of the first Latin America comprehensive law that was strongly influenced by the EU regulation. As a consequence of that, Argentina was one of the first countries in obtaining the adequacy decision of the European Commission. And recently we learned about Argentina joining Convention 108 of the Council of Europe and Convention 108 Plus. And there were many initiatives introduced in Congress over the last years. The last one was this draft bill developed by the Argentine Data Protection Authority, but all these initiatives are following the EU GDPR. So we expect to have news in the coming months on new regulations, perhaps amending the current PDPR. So I may stop here. I will be happy to answer any questions you may have, and thank you very much.
GDPR certified cloud vendor like IBM. How much compliance has been outsourced to IBM, and what processes does the small business need to build internally? So Sam, can you answer this question?
Sure. So sorry, just to clarify, if a small business has been CBPR certified,
Yes.
that they work where they
Yeah,
work.
and it's a cloud vendor like IBM. So how much compliance has been outsourced to IBM? And what processes does the small business need to build internally?
Yeah, so in the event that the larger business with whom the vendor is processing data on behalf of, if that larger business is also CBPR certified, then they haven't outsourced any compliance, with the exception that they may have chosen only to work with the vendor based on them having the CBPR, or what I mentioned earlier, the associated privacy rules for processors certification. So there are some examples. There are two larger tech companies that are CBPR certified. I can't name them, but they have informed the US government that increasingly they are looking at requiring any new vendors to have the CBPR certification, because what it does is it expedites their due diligence process. They still have to conduct due diligence on the vendor, but if they have a certification like the CBPR, that can signal instantly that they're already abiding by similar international privacy and data protection principles as the large company. So it depends on what the relationship is, if only one has the certification or not. But I just can tell you that increasingly larger companies are scrutinizing their new vendors more and more in terms of what kinds of certifications or codes of conduct they use.
So connecting with that question, because that is very interesting for us, since Argentina is a large provider of tech services to the US. So you were saying that you are thinking of new criteria to approve new countries into CBPR. So what are you thinking of those criteria, and what would be those members that you're thinking that might be eligible for CBPR?
Yeah, so it's a great question. We're still finalizing what those criteria will be. At the moment, nothing is changing in terms of the extension process, as it is under the CBPR system. What we're looking at to be different is that we're considering sort of a tiered membership framework similar to organizations like the OECD or ISO. And the primary reason we're doing that is because we already are in conversation with at least a dozen other countries or jurisdictions in some cases about future membership in the global CBPR forum. But some countries or jurisdictions are signaling, for example, that they have an interest in being part of this network in the future, but they need some time to evaluate how it operates. They want to be part of for example, maybe be part of the cooperative enforcement network, but not nominate an accountability agent yet. There are some countries that want to kind of take their time joining the system, and we support that. So we're looking at sort of a tiered membership process. And then as far as just general requirements for new members, like I said, at the moment, nothing is changing, but because this was an APEC creation and it was incubated kind of like a startup in APEC, since this is the first time that we will be evaluating applications from countries that are outside of APEC, we need to determine as a group, for example, whether or not votes on new membership will be by consensus or majority. Will there be a formal review process if one country, for example, says they want more time to evaluate a new member? We're going through questions like that. But I think the important thing to note is that there will be multiple avenues, I think, for countries to join the global CBPR forum if they are interested. And we encourage any interested countries or economies to talk with not only the United States, but the entire group, because this is not a US-led initiative, it's a collaborative process. We are certainly out there talking about this a lot, especially in Latin America, but we are increasingly looking for countries to, prospective members to engage us as a bloc so they get the information they need and can hear different perspectives.
Okay, thank you. Thank you very much. Thank you. That was a very interesting question. So maybe that connects with what was asked before by another question from Argentina, that is if Argentina is considering joining the CVPR. Maybe what you have answered validates what she has already asked. So Mariano, another question is, what are the next steps for what is the draft law that is being considered now in Argentina? What is the next process that is going on with the law?
Sure, thank you. Well, I suppose you're meaning the draft bill, because
Yes, exactly.
okay, yeah. Well, now as I mentioned before, the DPA is considering all the commentaries that were submitted by the parties, and it is expected that a new draft bill or a new version of this draft bill will be released. This should be the document that the executive branch will consider and probably will be introduced in Congress in the next couple of days, we expect, according to the official schedule. And then probably will be analyzed, evaluated, discussed in Congress even this year or next year. I think that it's a great consensus on this draft bill. I mean, I think that the DPA has made a good effort in a very short time period of time to elaborate a very robust document trying to amend this, that is trying to amend the law. And although, of course, there are many stakeholders that could say, well, okay, this article can be amended in a global approach. I mean, analyzing the big picture, I think that the document, this draft bill makes sense, and so I don't see that the draft bill will face many objections during this parliamentary evolution to be finally considered a bill or a law enacted by the Congress, hopefully this year or next year.
Thank you very much, Mariano. One last question, Sam. So many of the countries that are favored by the GSP know about digital economy and the standards that the US are looking for in countries like Ecuador, Paraguay, Argentina. So when you think about data protection and digital economy and data transfer, what would be the position of the DOC looking for the legible standards?
So are you talking about, when you say the GSP, you're talking about general system?
Yes, of reference.
Yeah, I mean, I honestly, I can't answer that question at the moment. It's not something that I deal with directly. We're certainly happy to follow up on that, but it's not something that I'm deeply engaged in. I do not work in general with a lot of multilateral organizations or initiatives. Most of my work is bilateral in nature. Yeah, I mean, it's certainly something I'm happy to follow up on. Apologies for that. No,
I didn't want to put you on the spot.
No, it's a great question.
No, but regarding is digital economy one of the issues? So I was wondering, just taking this, is CVPR was also in the agenda that they were debating at the Congress? That was why.
Yeah, I can just say that we certainly have socialized the CVPR certification when it was purely an APEC and this global initiative in multiple fora, including the OECD, and also WTO conversation. So I mean, I'm giving a presentation to a legal course in Peru next month that is, related to digital trade issues in the WTO. And I certainly will talk about the CBPR certification and its applicability to and its relevance to some of these issues. I unfortunately don't have a formal, position of the DOC on that.
Well, thank you very much. I think we just run out of time and we are good to go. I don't know if you want to give the closing remarks, Fernando.
Simplemente felicitar a todos los que han participado. Sabemos que crear buenas regulaciones van a potenciar el flujo académico de negocios y siempre la construcción de estas regulaciones empiezan por pensar un proyecto de desarrollo, siguen por consolidarlo en leyes propias y finalmente avanzar hacia un proceso de convergencia con otros países en un mundo donde lo global sin duda es innegable. Así que Argentina está en ese camino, pensar su desarrollo, construir sus leyes, discutirlas en el Congreso y luego avanzar hacia distintas negociaciones que permitan complementar esas leyes con los acuerdos que sean necesarios. Así que apostamos a que Argentina sea un gran actor en el mundo de los servicios basados en conocimiento y ahí la protección de los datos personales es clave.
Thank you very much all. This is our